Today we're looking at a sovereign citizen in court who insists on representing himself because, according to him, hiring a lawyer, having a driver's license, carrying insurance, and generally following state law all conflict with his religious beliefs and what he calls God's law. This is his final pre-trial hearing. And this time there will be a jury trial to finally bring the case to a resolution. We'll watch this hearing today. And in the next video, we'll cover what happens at the jury trial. Let's get started.
Okay, my next case is Andrew 2040-2730. Good morning.
Happy New Year.
Happy New Year. We're set for a pretrial readiness date. Are you ready for trial on the 15th?
I am.
Okay. And Mr. Myers, is this your case?
It is ready.
Are you ready for trial?
People also are not so ready for trial time.
For the prosecution, any pretrial issues that we need to take up?
Just one thing, Your Honor, I'm not sure if it's a pretrial issue. From what I'm seeing, I'm not 100% sure if Andrew has come to our office to pick up discovery yet, and so I just wanted to get kind of an update on that. We can give him the sheet again today, just so that we're not there the morning of trial, kind of showing the discovery in the case.
I just want to make sure that I've done a full Arguello advisement as well, because I think we had... All right, I don't think I have, so I'm just going to make sure, Andrew, that you understand. This is an advisement I'm required to give if someone decides to represent themselves, and so I just want to make sure that the record's clear. All right. That you are making a choice to represent yourself. So do you understand that you have a right to represent, be represented by counsel throughout this case?
I've been told that. As far as the benefit or firsthand knowledge of communicating with any legal professionals on the matter, I really don't have experience on the matter to speak and say, yeah, I understand what that would. But I don't want to cause controversy, and I don't want to be belligerent or cause dishonor in your courtroom. And I hope that, because we've all known each other firsthand since July 1st of last year, I hope that I haven't done that ever in your courtroom.
Okay, so I have some questions under the law I have to ask, so I just need to make sure that the record's clear. So do you understand that if you cannot afford an attorney, then one could be provided to you free of charge? Do you understand that? So that would be the public defender?
Okay, I comprehend that.
Okay. And so the process for applying to public defender would be you'd go over to their office, you'd fill out an application, they'd say if you make below a certain amount, then you could have that attorney appointed. Do you understand that?
Someone like Miss Alika Johnston.
Johnston, yeah. She works for the public defender's office.
Absolutely.
Okay. And so these are just questions I have to ask under the law. So I'm not trying to quiz you, but do you have any legal training?
Did I go to law school or?
Do you have any legal training at all? Any legal classes?
Every time they say that, I can't help but wonder, if you don't have any legal training, why are you acting like you do? It's the same as asking someone who needs surgery if they have any medical schooling. No? Then why would you want to perform the surgery yourself? Okay.
And then for the failure to display proof of insurance, you're facing a maximum sentence of a year in jail, $1,000 fine. There is a mandatory minimum fine depending on how many priors you have. It's either $500 mandatory minimum fine or $1,000 mandatory minimum fine. Although the court can half those mandatory minimum fines if you provide proof of current insurance. Driving under suspension is a traffic infraction, and as well as expired license plates. So you're facing up to $100 fine on those cases. Do you understand the possible penalties that you're facing?
What you're telling me about?
How far have you gone in school? All the way? Do you mean you graduated from public school? Yeah, just how far have you gone in school?
Before 2020, I was known as a master electrician. So I had completed, some stuff with Emily Griffith and had even a license as a master electrician, and was at that time, purporting myself to be an electrical contractor.
Okay. So did you graduate from high school or get your GED, or you have a diploma from your high school? Okay. And then Emily Griffith, for the record, is a trade school, but can also have like a secondary school beyond high school. Is that right? Okay. All right. And then, are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
I'm not.
Okay. Do you understand that criminal law is a complicated area, and that an attorney trained in this field could be of great help in preparing and representing your defense?
Is this criminal case?
This is a criminal case.
I comprehend that.
Okay. And do you understand that you have a right to remain silent, and that anything you say can be used against you in court?
I do not understand that, because I was compelled to participate in the competency evaluation, and when they said they called, and I really have honest phone records from Comcast whether anyone called or left a voicemail, and they didn't call the number that we provided them, and I went to jail for that for 3 days because I didn't want it. I wanted to remain silent and not testify against myself, but they contracted a psychologist from Canada who works on a case-by-case basis, and she basically, made me uncomfortable and threatened me and said if I'd already gone to jail for 3 days because somebody said they left a voicemail, and I didn't want to testify against myself. So as far as the right to remain silent with someone threatening me to go back to jail with like a gun in my head, I am forced to go against my beliefs.
No, you're free to believe you don't have to follow Colorado state law. But the moment you act on those beliefs in public, you'll quickly learn that actions have consequences.
Okay. So in trial, what will happen is if you make statements, the jury can take that in consideration of what statements you're making. So during trial, if you have an opportunity to testify, and we'll talk about that in the middle of trial once there's that time for any defense case. But any statements you make in court in front of the jury, those could be used against you. Do you understand?
And I really didn't come here today either to make any statements. I didn't know that we were going to have questioning like this.
Yeah.
Where I'm still, all these questions that you're asking me, I'm answering them under duress.
Okay.
Because I'm supposed to be a judge downstairs with Judge Gorman 7 minutes ago over the exact same stuff.
Mm-hmm.
And I've already done some time. I don't want to cause dishonor. I don't want to cause controversy. I'm seeking to correct my status. And I'm here by special appearance. I don't know what a fashion plea is. And last time I was with you, I was going to ask, you said a word to me if I found anything, and you used this word. I was about to ask you what that word was or what it meant, and then that's when Mr. Myers approached me with the discovery. And so I was still trying to focus on what we were talking about or what you were saying. Do you remember what that word was? It was about if I found anything in the time that when we'd last seen each other, and I think the word started with a D, and it was like dis
crayon eater is dumb as fuck. Maybe
something. Did you find any? I trust that it was like a question, but it was you were saying I trust that you didn't find any. And
I don't remember what I said, but
that's right. When Ian came up to me and
let me just ask you these questions then. So it sounds like you understand that at trial, if you decide to speak, that those words can be used against you. These are questions I'm required to ask because you're representing yourself, and I'll talk about the process for trial. But you should understand that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. And so do you understand that you have a right to confront the witnesses against you and cross-examine them? So in trial, the way that would work is if the prosecution calls a witness to testify, that person would get sworn in. The prosecution would ask those people questions, and then they would sit down, and their direct examination would end. That would be an opportunity then to cross-examine them or ask questions. So you don't have to cross-examine someone. The burden of proof is on the prosecution, which means that they have to prove this case beyond a reasonable doubt. You're not required to ask questions, but you do have a right to ask questions of those witnesses.
I could depose these witnesses, basically.
Well, we don't use the term depose, but you can ask them questions. Okay. And so you can ask them questions under the law as part of the trial. Do you understand that? Okay. And do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? So if you believe that someone, you'd like to bring in a witness, I'm not sure if there was anyone there with you on that day, but if there's someone that would come voluntarily, you can just ask them to come in and they could testify on your behalf. If you want someone to receive a court order, there is a process that you would go in. You'd file something with the clerk's office asking me to approve those subpoenas. If I approve them, then you would have someone not related to the case serve them. So you could have a private process server or the sheriff's office serve them and say, this is a court order to come to my trial. You could also have a third party not related to the case serve those people and ask that they be here. So do you understand that you have the right to have witnesses you choose court ordered to be here and testify on your behalf?
What do you think the likelihood would be of us summoning the Attorney General of the state of Colorado or the Registrar General of the state of Colorado, if that's relevant to the ultimate facts that got me to make the mistake that I made?
I'd say the chances of you getting a subpoena for the Colorado Attorney General are basically slim to none. I'd say the likelihood of you getting a subpoena for the Attorney General of Colorado is about slim to not gonna happen.
So you can always file something in writing, and then because you're not represented by an attorney can issue those subpoenas, but because you're representing yourself, you have to file something with the court, make grounds as to why you believe that the court should approve that subpoena. And so I would say I've never seen the Attorney General for Colorado come in and testify on a traffic case. You can always file something in writing, and I can take a look at it. And let me just correct the record. Okay, go ahead.
Can I do that as the authorized representative of Andrew Lawrence?
I know that you are appearing today as if you are representing you're the authorized representative.
I'm here making a special appearance. I'm here.
File whatever you'd like if you believe that someone can support your case, and then I'll file something in writing. That's the cleanest way to do that. I just want to clarify, I guess I said it was driving under restraint, but you're charged with driving without a valid driver's license. And let me just confirm that.
I was wondering if that was appealed to something different.
Okay.
When Mr. Myers came up at our last meeting.
They need to file something in writing then. So you're moving to amend the no valid operator's license?
If the court wants me to write a written motion, I can totally do that.
Okay. So currently you're charged with driving under restraint. The prosecution is moving to amend it to driving without a valid driver's license. So driving under restraint means that your license has been suspended. What this charge is that they're moving to amend is to driving without a valid driver's license, which is a different charge. Do you have a position on that motion?
I haven't been offered a plea as
Okay.
far as making a decision on it.
Okay. So that no valid operator's license comes with a maximum sentence of a $300 fine, 90 days in jail. That's the maximum sentence. So I just want to explain to you kind of what you're facing, and then we've gone through that long advisement about representing yourself. Based on my advisement, do you still wish to represent yourself?
I'm not sure of the legal implications of me using the word myself. You know, and when I'm looking at pro se, it's is it he speaks for himself?
So are you making a knowing decision to not use an attorney in this case?
Based on yes, based on what the Bible tells me that Jesus says about attorneys. No offense to anyone.
What he's probably referring to is Luke 11, verse 46 and 11:52, which say, "Woe to you lawyers, for you load people with burdens hard to bear." However, the Bible is actually criticizing religious leaders who were creating laws that made it nearly impossible for ordinary people to follow God, all for their own personal gain. What I find ironic is that they completely ignore 1 John 2, verse 1, where Jesus is described as a legal advocate for those who do sin. In the Greek text, Jesus is called a parakletos, which literally means one called to one side as a legal advocate. So while the judge is here to apply the law today, the Bible actually encourages having an advocate by your side to help you navigate it.
Okay. All right. So I'm going to find that your decision to, as I deem it, represent yourself because you're not using the public defender, you're not hiring an attorney, is made knowingly, voluntarily, and intelligently after a full advisal of your rights that you have in this matter. I've explained how to have a subpoena based on my observations of Andrew. I make a determination that he, based on his demeanor today, he does understand everything that I've just advised him of. And so I will find the waiver of counsel been made knowingly, voluntarily, and intelligently. So the prosecution has said you have not picked up discovery, which is the evidence in the case. So we can give you information to do that, but so that there aren't any surprises on the day of trial, you should go there today to pick up that discovery and make sure that you have that so that you're prepared, okay?
I do have another case.
In front of Judge Goldman, yeah. We let them know that you'll be late.
If anything goes wrong in there, how would I get the discovery? Say I was put in the dungeon?
File something with the court, and then we can talk about it on the day of trial. So I'm going to explain to you the way that trial works. And so the morning of trial, what will happen is we'll check in with everyone to see if they're ready. I would suggest that you watch a trial beforehand. I do have a trial that I believe is going on this Thursday, so you can either come in and watch. I usually live stream my trials unless the defense objects, which means that you could log in and watch the trial. So then when we're ready, the jury will come in. We'll have 12 people that will sit in the jury box, and then we will have some extra people that will sit behind the prosecution. We will ask questions, preliminary questions of everyone that are legal ways that they could get kicked off the jury. For example, we can't have someone that's a police officer serving on our jury because of the charges. So then we have and ask questions of everyone, and then we will ask questions of the 12 people individually. I ask questions of everyone, and then I turn it over to the prosecution. They have 15 minutes to ask questions of the jury to see if they're a good fit for the jury, and then you will have 15 minutes. You don't have to ask them questions, but everyone gets equal amount of time. After that point, I'll ask if there's any challenges for cause. What challenges for cause are whether you believe that under the law, this person cannot be fair. And so there have to be legal reasons for them to not serve on our jury. Once we decide the challenges for cause, if anyone is dismissed for a challenge for cause, the extra jurors that we have in the back will sit in that person's seat. And then we do what's called peremptory challenges, which means that each side gets three people that they can ask not to be on the jury without stating a reason for doing so. So what will happen is we'll go back and forth for each party, and I'll issue a written order regarding this. But each party, so I'll say for the prosecution, you exercise your first peremptory, and then they will decide the jurors will be numbered. So If everyone's happy with juror 1 through 6 and they accept that jury, then we will have 1 through 6 on our jury. If someone says, no, I don't want number 6, then number 7 will then be on our jury. So we'll go back and forth until either party has accepted the jury as situated or they've exhausted their peremptories, meaning they've used up all of their 3 peremptories. So once we do that, then we'll have a jury. We'll take a break. I'll swear in the jury, and then we'll start the presentation of evidence. Then the jury will come back in. I'll have some instructions to read to them, and then we'll go to opening statements. Opening statements are not evidence, but they give you an opportunity to tell the jury what evidence you expect to be presented. You don't have to make an opening statement. You can also reserve any opening statement until the presentation of your case. So the prosecution makes their opening statement, and then I'll ask you if you'd like to make an opening statement. I'll give each side 10 minutes for that opening statement. Then we go to the prosecution will call any witnesses that they believe prove their case beyond a reasonable doubt. For the prosecution, how many witnesses do you intend to call? So what will happen is for each witness, the prosecution will ask that witness questions, and then they'll sit down, and then that will be your opportunity to cross-examine or ask questions. Again, you don't have to cross-examine them, but if you decide to do that, you've made a decision to represent yourself. However, there are certain bounds, so I can't help you through this, but I can explain to you my rulings. One of the things that people that represent themselves or don't have a lawyer, they get in trouble, is they try to ask questions that are not relevant to the case in question. So there may be an objection on relevance, and I'll kind of explain to you what you have to, but you have to focus on whether you are guilty or not guilty of the offense and the charges are from that day. The other point that people that represent themselves get into trouble is that they start to argue with the witness. Just make sure that you are asking questions and you're not arguing. Okay, all right. And so then your questions will be done. The prosecution can do what's called a redirect, which asks questions that are related to the questions that came up. So they can't go through everything again, but they can clarify things that came up in cross-examination. We go back and forth until, for each witness, that same process. Then the prosecution rests, and then there will be time. I'll give you a full advisal as to whether you'd like to testify to the jury, and I'll give you an explanation of that. That would be the time to call any witnesses that you believe would help your defense, although again, you're not required to present any evidence. But any witness, or if you choose to testify, will be subject to cross-examination. So by the prosecution can ask your witnesses questions just as you were allowed to ask them questions. You will also be allowed to do what's called redirect, which is, again, if after the cross-examination is done, you'll be able to clarify anything that came up. Once you rest, the prosecution will do what's called rebuttal, which means just asking calling any witnesses that they believe rebut what came up in your case. Then everyone rests and we go to closing arguments. I'll give 10 minutes for closing argument if we are doing closings before 4, 15 minutes if it's after 4 o'clock. And then we read jury instructions, read jury instructions, then we go to closing, and then the jury will deliberate, and then we'll come back in, and once they return a verdict, they'll come back into court. Do you have any questions about the procedure?
Yes, I have a question. Will there be cookies and coffee provided for the jury during this time?
Anything else for
Real
the
cookies and
prosecution?
coffee. Not to leave cookies and glue coffee the sovereign citizen drinks every morning.
We have one witness.
Okay.
So it should be just one witness that people are calling in our case in chief. A subpoena has been sent out to that individual. They have accepted that subpoena and will be here on the dates of trial. The other two quick things from the people, Your Honor, is did the court still want me to file a motion to amend, or did the court?
Yes, please, so that we can give Mr. Velasquez can be served a written explanation of that charge.
Yes, Your Honor. And just the final thing, I just wanted to put all parties. First of all, I'm handing the defendant in court today the sheet on how to get the discovery from our office. And put on the record, I've made this record when I've given Andrew that paperwork in the past, he is required to give a government-issued ID to pick up the discovery in the case. So I just, again, wanted to flag that potential.
Is there a way to flag the case to just ask that they provide Mr. or Andrew a discovery without that ID?
I can put that into my file, Your Honor. I think the discovery, kind of their procedures might be a little bit over my auspices, but I can put that in our file to see if they'll be able to do that.
Okay.
And then the final thing from the people, Your Honor, is I just wanted to put all parties on notice that depending on how some of the events go at trial, the people might invoke Rule 201 for the court's minimus that was published publicly on November 18th of this year with just some of the relevant information depending on some of the stuff that comes up at trial to give to the jury. I just wanted to put all parties on notice, but that is the only record from the people.
Okay, so you would ask the court to take judicial notice of the minute order? Okay. So what that means is that they may ask the court to take notice under the law that this minute order contains information. I'll take that up in trial because I don't know how that would be relevant at this point, but it may be relevant. So we'll take that up at trial, but he's just placing on notice. There's an evidentiary rule called judicial notice that the court can take notice of certain things, including court records.
And that's Rule 201?
201. Mm-hmm. Okay.
And Your Honor, if the court could, I can put in my file as well, but if the court puts an order potentially saying that he should be ordered to pick up the discovery, obviously understanding the issue of the government ID, I can also note that for our staff. I think hearing it for myself, but also hearing it from the court would be beneficial as well.
Okay. I mean, I'll put in a note that he receives information. I'll tell him that he has to pick it up, but it's his determination of what he'd like to do. If he's making a choice not to, then...
Yes, sir.
Does that help? Well, like what he's saying, for them to release it?
I don't understand your question.
Like if I go down there with no government-issued ID and no...
Do you not have a government-issued ID?
How can you claim to be a master electrician without a government ID?
Okay.
How would anyone verify your license if you can't prove you're who
How
you say you
many
are?
pages of
You're
discovery
literally
is there?
your own worst
Body
enemy.
on camera as well.
Give me just one moment, Your Honor. It is just a traffic case. There is body-worn camera. The totality of the discovery is just 19 pages.
Okay. I guess what I'll say is that I'd ask that you just flag the case and say that Mr. Velasquez does not have, or Miss Andrew does not have a government ID, and then maybe be prepared to just print that out so that he can have it. Can you print out the pages today?
I was just going to say, I can email Laura the 19 pages of discovery to give her hard copies, which is like the summons, the reports. I will say, though, for the court, the body-worn camera, able to just give...
Okay. So I guess, could you be prepared for the clips that you may provide at trial? On the morning of trial, I'll give you an opportunity to show that to Miss Andrew so that he is able to at least see it before, but also that we'll note that the prosecution will provide that and then we'll hand that to you, okay? The written paperwork, but we can't provide you the body-worn camera.
Well, I think what he's saying is that it would be difficult to do that, but I could receive it electronically over the internet via email.
I think it's too large. Mr. Myers, have you made a determination of what clips you're going to be entering into? How long is the body-worn camera?
Body-worn camera clips, Your Honor, when we have reviewed it, that would be admitting at trial will probably be just a few minutes in totality. I think it will be probably 2, maybe 3 clips, but they should not be very long in nature. So
Okay.
we'll eventually go back to the jury if it's tendered at trial would be just a few minutes of body-worn camera. So we can definitely, the morning of, take a moment to show him on our devices.
Okay.
What I could provide also, what are those things called?
A USB?
USB
A flash drive? Yeah.
Flash drive. I could provide that and then get the
Are you able to just show him the clips today? That way we're all ready for trial on the
I
morning.
can see the whole.
Mhm.
The whole.
Yeah, it's difficult. not having an ID. So
I know.
I guess what I'll ask is that court asks prosecution to flag the file and that prosecution to provide discovery without an ID, and then you can talk to your office if that's something that they will do.
We'll flag that for our office.
Okay. And then we'll print out that paper for you today, Andrew. And then any other questions for me?
Do we want to disclose the name of the witness today?
Sure. I think it's already been disclosed, but which witness are you planning to call?
Yes, Your Honor. It is Officer Donovan Reetz, R-E-E-T-Z, of the Wheat Ridge Police Department. And it would be his body-worn camera that we will be introducing to the jury. I will just also note for Andrew, there was, I think, 5 or 6 different law enforcement officers that arrived. So the body-worn camera for all of them is hours long. So for the morning of trial, obviously we're only introducing Reetz at trial, but just for his knowledge, there's hours of body-worn camera in this case with the police response.
Okay. So I guess I'll just ask that we talk to your office and provide that. Okay. So Andrew, go there today, and then hopefully if there's any issues, you can request a hearing prior to trial, and we can talk about that. Okay. All right. Any questions for me?
Did you recall what the word was?
I don't remember the conversation we had a month and a half ago. My apologies.
All right, it looks like we're going to trial. Unlike last time, I actually have the full jury trial footage ready. Well, not completely, because the trial ran over 4 hours from start to finish. So today I'm going to spend some time cutting it down to just the relevant parts, and I should have it ready for you tomorrow. What you saw today was just a preview of the level of nonsense you're going to see in the next video. So I'll see you guys there. Outro, the stupidity preview. If you liked the video, hit the like button. If you didn't, hit dislike. Either way, leave a comment below and subscribe with notifications on so you don't miss any of my content.